I notice I lost my name tag, so I'm David Rivers for anybody who doesn't know me. I'd like each of the panel members to give me an answer to this. Article 15, Section 2 of the Nevada Constitution provides the oath of office. Can you tell me explain to me your understanding of the oath and the penalties for the violation of that oath? Listen.
It's my understanding that when we take the oath of office to do our duty as a judge, we are swearing to uphold the law and apply the law. And for me, what that means to apply the law is very clear. It's to apply the law as it's written with respect for the intent behind the law, and not to apply a law that in a way that I may want it to be. My job is, as a judge, is to apply the law, not to make the law. And we have an oath, we have an obligation to do that and to abide by the judicial canons, to be ethical. And our penalty we would face for violating our oath would potentially be to be impeached and to be removed from the bench. So that's what the oath would mean to me and what the consequences would be as I understand them.
Okay.
I interpreted your question a little bit differently. If a witness takes an oath, they're swearing to tell the truth. I have very little tolerance for people who lie under oath, and I would have some severe penalties for perjury, and I would have less tolerance for any attorney who allows a client to knowingly commit perjury. As a lawyer, we have an obligation of truthfulness with the court. There have been cases in my career where I knew my client was being less than truthful, and I had, in some cases, to tell the client, you need to correct your testimony or you could be penalized for perjury. The system operates with integrity, and well, it should.
Thank you.
Dave, this is Ron Israel. I already did take that oath as a short trial judge. It was administered at the time by Chief Justice Mark Gibbons. And to me, that oath is very important. It requires us to be fair and impartial. I certainly think that I have done that. I have, in the 8 jury trials I've done, I did one bench trial. As I said, I have another one on Tuesday. I think I've done obviously well because I continue to be chosen as a short trial judge. As you know, you have the right to preempt judges, or actually it's a right that both parties have. And the rulings that I've made so far haven't been appealed, which they do have the right to do. Yeah, I take it very seriously, and I think its impartiality is important, and using the evidence code as the law requires.
Thank you. This question is for the panel. My name is Travis Berry. Let's assume you're sitting on the bench and you receive a motion to quash. It involves a veteran who is in another jurisdiction, who is currently receiving treatment through the VA system. The VA becomes aware of this veteran having a felony warrant in the state of Nevada, and the VA lets the veteran know that if that warrant is not quashed, he will no longer be eligible for treatment. So you receive a motion to quash that felony warrant in Nevada, even though the veteran is in Alabama. And at that hearing, the DA is screaming We want that veteran to come back to Nevada because they jumped probation. They failed to comply with the probation order. What are you gonna do?
Well, I'm certainly going to listen to both sides. You say the DA is screaming and wants and doesn't want the warrant quashed, wants the veteran to be brought back. And although you said if, and I want to make sure I'm clear, that if the veteran is indeed extradited back to Nevada, he will not receive the, did you say, medical treatment that he?
It'll mean he'll be pulled out of the treatment in which he's currently receiving through the VA system in another jurisdiction.
Well, I would certainly want to know what kind of treatment he was receiving. I mean, is this a situation where to remove him immediately from that treatment would be life-threatening? Is it something that he could receive treatment here once he's extradited back? And I would certainly take that into account, because if it's a life-threatening situation, then I think you would have to factor that into your decision. Maybe it's something that will resolve in a bit of time, and at that point, he could then be brought back to Nevada. And if it's not a life-threatening situation and there's treatment that can be sought here, the bottom line is if he's violated the terms of his probation and there is an outstanding warrant, he does need to be held to the consequences of that violation, and he does need to be brought back to Nevada. But again, I think ultimately it would depend for me on knowing more facts about what the treatment was and if it's life-threatening, and then I would probably allow him to remain where he was if it's life-threatening until he could be stabilized and then perhaps brought back. But I think ultimately he does need to be brought back if he has indeed violated the terms of his probation.
My name is Jack Howard. As you folks know, there are certain federal protections that attach, particularly for active military personnel stationed overseas. So the federal laws provide for certain protections. The answer to your question is you have to apply common sense and look at every case. Certainly, if there's a veteran and he's receiving meaningful treatment, then the judge may need to step up and say what the case will continue eventually. So I think it's more important that the veteran maintain treatment, and the DA or whatever, the defense attorney, should take the entirety into consideration.